Okay, hello and welcome to the Refugee Welcome Collective Lunch and Learn series. In these sessions, we aim to bring you interesting and timely information. Whether you are a volunteer, community sponsor, resettlement agency staff, a local advocate, or just someone who is interested in learning more, we hope that you enjoy today's session on fair housing. Refugee Welcome Collective collaborates with partners to provide in-depth training programs, weekly lunch and learn sessions, resources, and on-demand technical assistance for sponsors, resettlement agency staff, refugees paired with sponsors, community and institutional partners, and others to support quality community sponsorship programs across the United States. As a reminder for everyone joining us today, everyone on today's webinar is automatically muted. However, if you have any tech issues, please submit a question in the chat or the question box so that we can assist you. There will be time at the end for a Q&A once the webinar is, once we're done with the presentation. Additionally, the presentation and any resources and recordings will be sent to everyone following today's webinar. This brings us to our presenter for today. Our presenter is Lynette Pearl, Senior Program Officer of Housing of Refugee Housing Solutions. So welcome, Lynette.
Thank you for the introduction, and I am going to let me know when you're ready to share screen, and I'm gonna get started. Okay, give me a minute to get started. And Grace, you're my eyes and ears. Can you see my screen? I'm sorry, you guys, I know I'm not the most savviest, but let's do this. Try this one more time. And can you see my screen? Okay,
yes.
Cool. So thank you for that introduction. We are a capacity. I just want to talk a little bit about RHS, and then I want to move on because we have a lot of material to cover today. Who are we? We are a technical assistant and capacity building support project for resettlement practitioners, housing providers, and community groups, which also includes refugees and other newcomers to the United States. The one thing about our team, we do have a lot of stakeholders, which includes government and private sector partners. And we do develop and implement innovative initiatives to increase availability and the affordability of housing for refugees and other newcomers. And we are a great team. We do provide technical assistance and training. So feel free to go to our website if you want to book a TA session with one of our team members, or you want a specific training. And this just highlight all the few services we do provide. Again, TA trainings, we do have a lot of resources, and we do establish innovative partnerships, again, to increase housing opportunities for newcomers. And this is just a snapshot of some of the resources that we have on our website. We have toolkits, we have we have all types of just wealth of information. So I do highly encourage you to go to our website to look at our resources. So let's jump in. Our learning objective today for fair housing is to understand the summary overview of the Fair Housing Act. And we need to know why the act is so important for refugees and other newcomers. And we are going to highlight the federal protected classes. And then we're going to talk a little bit why it's so important for you to know your state protections as well. And then we're going to talk about how to support a newcomer tenant if you feel that their rights have been violated, or helping them file a complaint. And I want to put this disclaimer out this session is for informational purposes only and should not be relied upon as legal advice. So on April 11th, I want to talk a little bit of history of Fair Housing Act because it's so important to understand where it came from. On April 11th, President Lyndon Johnson signed the Civil Rights Act of 1968. This followed the Civil Rights Act of the 1964. The 1968 Act, it did expand on previous acts, and it prohibited discrimination concerning the sale, rental, and financing of housing based on race, religion, national origin, sex, handicap, and family status. This has been amended. It's also known as the Fair Housing Act of 1968. Now, the enactment of the Fair Housing Act on April 11, 1968 came only after a long, challenging journey. From 1966 to 1967, Congress regularly considered the Fair Housing Bill, but it needed to garner a strong enough majority for its passage. And this is so important why I want to talk about the history of this act. However, when the Reverend Dr. Martin Luther King Jr. was assassinated on April 4th, 1968, that's when President Lyndon Johnson utilized this national tragedy to urge for the bill's speedy congressional approval. So since the 1966 opening housing marches in Chicago, where I'm from, Dr. King's name has been closely associated with the fair housing legislation. So that's why I wanted to do a brief overview of this act, where it came from. Now, as I stated earlier, the Fair Housing Act, it is a federal law that prohibits discriminatory housing practice based on one's person's color, race, religion, sex, national origin, disability, and family status. Now, the Act's foundation is the right to choose. That's so important, the right to choose. The Fair Housing Act does guarantees the right to choose housing free from unlawful discrimination. It protects people from housing discrimination in various transactions, including rental, sales, lending, and insurance. So the question is, why is it so important? I mean, it's obvious, but the FHA ensures that a protected class member is not discriminated against during a housing transaction. Many newcomers, they do have experienced discrimination, and you as a staff member, sponsor, or volunteer, you do play a crucial role as an advocate. You can be their advocate. You understanding their rights helps keep them secure housing of their choice, and also allows them to practice or file a complaint if their rights have been violated. And that is one of the biggest misconceptions, that newcomers feel that they don't have rights when it comes to fair housing, which they do. Again, who's protected by fair housing laws? Housing laws protect all individuals seeking housing, including renters, homeowners, persons obtaining a mortgage or homeowners insurance, and others. Now, in this training, I am going to cover federal protections. However, it's so important that you know your state and local laws as well. All states are required to comply with federal housing laws, but some states and local laws are more expansive and provide additional protections. So, for example, I mentioned I'm from Illinois. In the state of Illinois, one's source of income makes it unlawful to be discriminated against. And here is just a snapshot of some additional protections that are available in the state of Illinois. I'm going to show that. So that's why it's so important. Yeah, you need to know the federal, but you also need to know what are your state and local protections as well. And again, I love examples. Here is a snapshot of the state of Illinois. As you can see, of course, you have your Federal Fair Housing Act, what is protected. Under Illinois, you have your Human Rights Acts. As you can see, it's more expansive. And Cook County even narrows down the county, and then also Chicago Fair Housing Ordinance. So again, know your federal, know your state, and know your local rights. Now, the Fair Housing Act, it does prohibit housing providers from discriminating against people because of disabilities or treating them less favorable than others because of their disabilities. The Fair Housing Act defines individuals with disabilities as those with mental and or physical impairments that substantially limit one or more major life activities. Now, major life activities include caring for oneself and performing manual tasks. Now, when we talk about disabilities, we want to talk about a reasonable accommodation. It is a change or an exception or adjustment to a rule, policy, practice, or service. So a reasonable modification, there's accommodation and modification. They're slightly different. A reasonable modification is a structural change made to the premises. So the purpose of a reasonable accommodation or modification is to provide equal access to housing for people with disabilities. Now, reasonable accommodations and modifications can make otherwise inaccessible units accessible for those with disabilities. So this is an organic way to increase housing opportunities in areas that have transportation and other convenient amenities for those with disabilities. So you're wondering, what is a reasonable accommodation? Well, a reasonable accommodation are changes in rules, policies, practices, services that ensure a person with a disability has an equal opportunity to use and enjoy a dwelling, unit, or common space. Again, a reasonable modification is a structural modification that is made to allow people with disabilities the full enjoyment of dwelling units and related facilities. Now, who can request a reasonable accommodation and modification? Now, if you have a newcomer client, they're an applicant and or tenant with a physical or mental impairment that substantially limits their major life activities, they can request a reasonable accommodation or modification. This may occur at any time, either during the application process, the signing of the lease, or during their rental tenancy. So even during eviction or renewal process. So the request can be made either by a family member or person acting on behalf of the persons with a disability. And we're going to talk a little bit about what that would look like when a person is being discriminated against when they're requesting a reasonable accommodation and modification. So I'm an example type of person, and I tried to give live examples when I was in housing, when I was a case manager or when I was a housing specialist. So here are some live examples of reasonable accommodation. If you have a client and they're doing an application and they want to be assigned an accessible parking space, but due to mobility challenges, they can put in a reasonable accommodation. If they need to have a floor unit, if they specifically ask for a floor unit and a floor unit is available during the application process and it meets the criteria, they actually qualify for that actual unit, they can pay the rent, they can put in a reasonable accommodation for that. Adjust rent payments. This is a big one to align with assistance income payment dates. So for example, if I had a client and their rent was due on the 1st, but they didn't get their disability check unless on the 5th, we would put in a reasonable accommodation to pay their rent so they wouldn't get late charges because of the date that their actual assistance came in. And another thing I want to highlight is allowed to live-in aid. If you have a client currently, they can be independent if they have someone that lives with them. They can request a reasonable accommodation for a live-in aid. And with the live-in aid, you would have to get documentation from a doctor stating that this person can be independent if someone can live with them. However, they cannot charge them rent, or they don't have to put them on the lease because they are a live-in aid. So there is a process to that, especially if you have a client, you're getting them, you want them to lease up in an income-based unit. Again, with income-based, the rent is going to be determined by how much income that client has. So if they have a live-in aid, they cannot count that live-in aid's income towards the rent because they're a live-in aid because of the reasonable accommodation. So that's very important. Now we're going to talk about reasonable modifications. Again, if you have a client, they need a grab bar in the bathroom, they have to provide that grab bar for your clients. Install visual doorbells or fire alarms in lower kitchen cabinets. If it's not a financial burden on the landlord, they have to provide those things. And the same thing with install a ramp to the front door. Again, it cannot be a financial burden to the landlord, but they have to make that reasonable modification. And they cannot discriminate against them if they're requesting these modifications or accommodations. How do you make a request? Well, you can make it verbally or in writing. I state the best practice is to do it in writing to hold the person accountable, the landlord or the housing provider accountable. Again, it's not mandatory. However, if you have a client that is going to be leasing up in a government-funded housing, it is required to be in writing. So just FYI. What if to do if there's no response? Again, that's why it's so important, even though if you ask for it verbally, but if you have writing, you can easily document when you request it for your client or when your client put the reasonable accommodation or modification, you have that date, you have the date that they actually submitted to the housing provider. If there's no response, then it can start tracking. There can be some discriminatory actions going on if they're not responding to the request. So that's why I highly recommend that you put the request in writing. And what should you put in your request? I'm sorry. It must be technically possible, as we talked about. It must not change the basic nature of the housing program being used. And it must not cause an excessive financial or administrative burden to the housing provider. And it must not cause harm or damage to others. So those are things you have to consider when assisting a client to put in a reasonable accommodation or modification. And I need to hurry up because there's so much. And there's reasons for denial. The request is not on behalf of the individual. There is no disability related needed for the accommodation or modification. And the modification impose an undue financial or administrative burden on the housing provider. And you can file a complaint of a reasonable request is denied. And again, this information will be provided for you if you feel that a client has a legitimate reason and they got denied their reasonable accommodation or modification. So we're going to talk about our protected classes. And the first thing we're going to talk about race and color. So when Congress passed the Fair Housing Act in 1968, one of its primary goals was prohibit racial discrimination in the sales and rentals of housing. Nonetheless, more than 50 years later, race discrimination in housing continues to be a problem throughout the United States. It is illegal for housing providers to treat someone differently because of their actual race, color, or perceived race or color. A housing provider may also not discriminate against a tenant or applicant because of their association with another race. So, for example, you could have a white tenant cannot be treated differently because he or she has an African American guest or spouse. I've seen that happen before. So I am an example type of person. Let's look at examples of this discrimination in this protected class. If a housing provider refused to rent to someone only because of skin color, race, or they steer a rental applicant to a building with renters of similar racial background, that's called steering. Steering is when you have a property manager, for example, say, hey, they're showing you the property and say, you probably want to pick a unit over in that because you have children and that children has a tendency to have more children in that building. That is considered steering. They refuse to rent to a person with darker versus light skin color of the same ethnicity. You say, well, that doesn't make sense. Well, for example, I'm going to use an example of myself and my sister. I am a chocolate African American, but my sister is a lighter skin. So, for example, if she goes in and the housing provider is willing to rent to her, but I come behind her probably a couple of days later and they refuse to rent to me because I am a different color. Even though we are the same ethnicity, but we have a different shade of color, that is still considered discrimination. I've seen that been done before. So just even if the housing provider is a person of that same ethnicity, they still can discriminate against their own ethnicity. So just FYI, I've seen it happen too. And states that they only rented people who speak to English. So we're going to talk about national origin. Now, the Fair Housing Act prohibits discrimination based on national origin. It's illegal for a housing provider to discriminate against an applicant or tenant because of the country or nation they or their parents or ancestors come from, or because they have a name or accent associated with a national origin group, or if they participate in certain customs associated with a national origin group. Now, the Fair Housing Act may be violated even if a housing provider does not know a person's particular national origin or it is mistaken about it. Landlords are allowed, however, to request immigration documentation and conduct inquiries to determine whether a potential applicant meets the criteria for rental as long as the same procedure is applied to all potential renters. Now, again, this is just an overview of how can I say? It's very important that you understand this a little bit, because sometimes you will have a housing provider and they unknowingly are practicing discriminatory practices. They might ask an innocent question. Again, you have to take in context what they're asking or what they're doing. So here are some examples. For example, if you have a Hispanic applicant, if they innocently ask how many children they have, but do not ask that of all applicants of that same question, that is a discriminatory practices. I've seen housing providers do that innocently. They put their own biases in, but that is that's discrimination. And they really don't know when they ask that question. You cannot ask that question unless you ask it to all applicants. They refuse to rent to a newcomer based on ethnicity. That's just blatant. Rent only to certain ethnicities, or tells the tenant they must speak English when outside of their apartment, or must speak English, period. Now, it's different if they need assistance with translation, but they cannot tell a tenant that they must speak English when they're outside of their apartment. That's just an example. We're going to talk about religion. Now, the Fair Housing Act prohibits housing providers from treating applicants and tenants differently because of their religion, or because they wear religious clothing or engage in religious practices and rituals. For example, they refuse to rent to a newcomer or steer a rental applicant to another property based on a stated or perceived religion. They discourage or prohibit religious art or decoration inside a rental unit. I've seen that happen too. Prohibit community room use for religious related purposes for only some religions, while allowing other tenants to use it for secular gatherings such as parties. I've seen that happen as well. So that is just some examples. We're going to talk about family status. Now, the Fair Housing Act, with some exceptions, prohibit discrimination in housing against families with children under 18. In addition to prohibiting an outright denial of housing to families with children, the Act also prevents housing providers from imposing special requirements or conditions on tenants with children. Under FHA, the marital status of adult tenant is irrelevant. It does not matter if the adult members of the family are married, divorced, single, or widow. That still goes under family. That's protected. So a single father with one child has the same protections as a married couple with children. I'm just using that as an example. FHA also protects families with children, even if the children aren't living with their biological parents. If that child is considered part of that family unit, then that's what that child is. You don't have to be the biological parent in order to be part of that family unit. So just FYI. And here are some examples of discrimination. They refuse to rent to a family with children, flat out, unless it's a senior living. That's different. If it's a senior living, that's a different situation. Designate a building or floor or unit as child-free, charges a higher rent or security deposit because a family has children, or make negative comments about individuals or families based on their family size or status. Now, I want to talk about this. I want to add this caveat. Now, there are occupancy requirements. So I know that a lot of newcomers have larger families. So a landlord would not be considered discriminating based on family status if they have a lot of children, if it does not meet the occupancy requirements, because they have to meet the occupancy requirements. So that's why it's so important, if you are working with a newcomer and they do have a lot of children, to find out, okay, if they're going to apply for this particular unit, what are the occupancy requirements for that unit? So when you're going in to help them apply, you know their family unit will fit that occupancy requirements. So just FYI. And we're going to talk about sex, gender identity, and sexual harassment. Now, the Fair Housing Act makes it unlawful to discriminate in housing based on sex. So in recent years, the department focus has been on challenging sexual harassment in housing. But in 2020, the U.S. Supreme Court issued a decision that expanded the Civil Rights Act of 1964 to include others such as sexual orientation and gender identity. So that has expanded under this category. So here are some examples. Not renting to an individual because of stated or perceived sexual orientation or because of their gender. An example, an applicant or tenant has an androgynous look and the landlord makes assumptions about a gender identity and so does not rent to them based on their perceived conclusion. That is discrimination. Not taking actions to protect domestic violence victims. This is domestic violence, but I also want to include victims who have been trafficked under this as well. A landlord does not allow a victim to break a lease or transfer to a different unit. So if you have a client that is experiencing domestic violence or they're a victim of trafficking and their perpetrator finds out where they live, they have every legal right to break their lease. The landlord cannot hold them to their lease under VAWU, Violence Against Women's Act. That's a federal law which has expanded. I know it says Violence Against Women Act, but it has expanded to all victims. They cannot hold them accountable to that lease. They have to break their lease or allow them to transfer to a sister property in order for their protection. Now, it is illegal for a housing provider or staff member to offer a reduction in rent. This is just an example for sexual favors. I've seen this happen many times before, and especially working with this population, they're very vulnerable because they don't know their rights. So I've seen landlords take advantage of populations that feel like, okay, I don't know my rights. Maybe they can do this and they cannot. So make sure that you check in often with your client to make sure this is not happening. If they make unwelcome sexual advances or off-color sexual comments, they are protected. That is sexual harassment and complaints can be made. Another big one I should have added on here, I have found in my work, it doesn't just have to be the property manager. It can be anyone who is acting in behalf or a staff member. You can have a maintenance person. Anybody that works for that property cannot, how can I say this? I want to say this to be politically correct. They cannot force themselves on any tenant because I've seen it happen. So it's very important you know your tenant, your client knows what their rights are. Or if something unusual like a maintenance man or maintenance person comes into their unit and they don't feel comfortable, they have every right to tell that maintenance person to leave and report it. Now, there is a way, if you have a client that you feel that they have been discriminated against during the application process or during while they are a tenant, tell them there's ways to prepare. Document all their meetings and phone calls. All interactions should be documented, or if you even review or you're part of it, you've seen it yourself, document. Keep detailed records about everything that was said. If there was other witnesses present, get their names. So if you have to they have to have their statements. Save copies of applications, signed leases, security deposits. If a complaint must be filed, make sure you get, again, written witnesses, statements of other people who saw the discrimination happen, full names, signatures, dates, and you can contact the Federal Housing and Equal Opportunity Office. And again, this information will be provided to you. But I highly recommend that you find out what your fair housing agency, local fair housing agency is, because they will take action quicker. And you will get a list of link to find out who your fair housing agency is. Now, the person does have up to a year with HUD to file the discrimination once it occurs, and in federal court within 2 years after the discrimination occurs. Again, this will be provided to you. I want to again focus on the local fair housing agency. I think it's better to contact them first because they're on the ground, they're more grassroots. And the good thing about the fair housing agencies, your local fair housing agencies, they also know your state and local laws better because they're actually implemented those. So they can actually do an investigation. They can also provide advocacy for they do provide advocacy for the housing provider, but they can also provide advocacy for the person filing a complaint. And they can also help file the complaint to the Department of to HUD. And they can also do a resolution if it's possible, because the goal is they don't want most landlords, like I said, they innocently do things and they don't know. So when that fair housing agency comes in and do the investigation and see that it's probably an innocent act, they try to come up with some type of solution. But if it's blatant discrimination, then they will take it and they will help your tenant or your client do the filing. So I highly recommend, if this is happening, get with your local fair housing agency. So I just want to thank you for that. Wait, something is off. I had more. I want to say, yeah. So this is, again, I just want to make sure we have time for questions. Again, my name is Lynette Pearl. If you have additional questions, feel free to email me. I'm at lpearl@cwsglobal.org. Or you can just go to our website and you can get an appointment with one of my team members. You can set up a TA. So I wanted to make sure that I covered that. For some reason, I think I'm missing some slides, but one thing I do want to talk about that's so important is, again, making sure that you're educating your client, because a lot of this happens due to a lack of education, and also keeping yourself updated on any current laws in your state locally. It's good to know federal, but you should also know your state laws as well.
Thank you so much, Lynette. So what we're going to do is we're now going to answer any questions that you all may have. You are able to come off mute if you have a question, and Lynette is available to answer any questions you may have.
Oh, was that thorough? Again, our team is working on a toolkit. So we'll have a toolkit rolling out pretty soon where you can, if you have any questions, the toolkit is going to have more examples, because I'm an example type of person. So we will have some resources available probably within a couple of weeks just regarding fair housing, because this is so important. This is my passion. I've been in the field, for telling my age, but for 19 plus years now. And I'm very passionate about this, and I'm very passionate to make sure people know their rights, because a lot of things happen due to the fact that people don't know their rights. They don't know their housing rights. And I have found now, being in this newcomer space, a lot of newcomers feel, well, I have no right to ask that because I'm a newcomer. No, you have as much as housing rights as anybody else. And that is one thing I stress so much to our staff members, but also to clients. You have rights. And it's very important that you know your rights so you won't be taken advantage of. Any questions?
It looks like you've come off mute. If you have a question, go ahead and ask.
Are there any questions in the chat by chance? Because I can't see. Let me see.
It does look like we have some questions in the question chat box. It says, how do I know if my housing provider is acting discriminatory practices? And what if he or she did not answer my phone calls while he or she answers other people's phone calls?
Oh, is there how do you, okay, this is an opening question. I would ask the person to please email me so we can do more one-on-one, because there's a lot of questions I would have to ask in order to answer that properly. So feel free to email me so we can set up a time, so we can talk about that, because I know we have some time limits. And because some other questions I would possibly need to ask you to drill down on that. And then to assist you. And I'm gonna put my email in the chat. Is that another one? We didn't have discrimination terms.
I think both of the questions that were in here are related to one another from the same person, so.
Okay, because I do say we haven't had discriminatory issues during the stay of our clients. However, some property management companies haven't been willing to work with us anymore due to our clients' behavior. Well, that's understandable. Again, there's a two-way street. You have your property manager has responsibility and the tenant has responsibilities as well. So that's why it's so important when you're leasing your client up to let them know what their responsibilities as being a good tenant. And we do have a tenant toolkit that breaks down how to be a good tenant, what a tenant is responsible for during the rental process. So it goes both ways. So unfortunately, if you have tenants that are not abiding by the lease, or they have a lot of lease violations, unfortunately, depending on what the lease violation is, a landlord has every right not to renew the lease or break it.
Right, any other questions? Okay, well, thank you again to our presenter for today, and thank you everyone for attending today's RWC Lunch and Learn. We would like to hear from you and receive any feedback on today's webinar, and hear your suggestions for future Lunch and Learn topics. We ask that you take a moment now to complete a survey. Use your phone to follow the QR code on the screen, or you can follow the link in the chat. And then we look forward to hearing from you. We'll give that just a few seconds so that you all can complete the survey. And while you're doing that, I just want to let you know that you will receive a follow-up email with a link to the recording of today's webinar. And on behalf of Refugee Welcome Collective, thank you for joining us, and have a great rest of your week.